Assalamualaikum. I'm from Group 1 from DLS 4B. So my group members Nur Farah Adriana binti Aminuddin and I Nur Syafira binti Ismail, Nur Hanisa binti Muhammad and Katrunada binti Hasani. So my group will present about industrial relation in Malaysia. I'm Nur Syafira binti Ismail. My matrix number 23 DLS 90F2030. So I will present about background of industrial relation in Malaysia. The industrial relation system in Malaysia operate within the legal framework of the Industrial Relation Act 1967. The act is enforced by the Department of Industrial Relation Malaysia DIRM and it regulates the relation between employers and their workmen and their trade union in the country. So what Act 1967 provide is first provision outlining the process relating to claim for recognition and scope of representation of trade union, provision relating of the facilitation of effective collective bargaining between the trade union and the employer, and subsequent conclusion of a collective agreement. Third, provision relating to provision and settlement of trade disputes, including referral to the Ministry of Human Resources and Industrial Court for a decision. 4. Provision relating to industrial actions such as pickets, strikers and lockouts. 5. Provision relating to the representation for claim for reinstatement by workmen. 6. Provision relating to the operation of the industrial court. 7. Provision relating to the investigative powers of the officer of the Department of Industrial Relation Malaysia. So that's all from me. I will pass to Farah Adriana.
Assalamualaikum and selamat sejahtera. My name is Nur Farah Adriana binti Aminuddin. My matrix number is 23 DLS 19F2034. Okay, for this video presentation, I'm going to present about the describe industrial relations. Okay, industrial relation is that field of study which analyzes the relationship among the management and the employees of an organization at the workplace, and also provides a mechanism to settle down the various industrial disputes. Okay, this concept evolved in the late 19th century because of the industrial revolutions. It is made up of the following two terms. 1. Industry. Industry can be viewed as an economic activity like manufacturing, producing, or processing of goods or services, which is performed by a group of individuals. Second is relations. Relations here refers to the connection and communication which pertains between the employer and employees within a workplace.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Hanisa binti Muhammad. My matrix number is 23 DLS 19F2044. Okay, today I would like to present my point. My point is explain tripartite system in Malaysia industrial relations. Okay, first of all is the Malaysia industrial relations system. In Malaysia is a tripartite tripartite setup consisting of the employer, the employees, and the government. There are three broad approaches to the decision-making process in manpower relations, namely unilateral, bilateral, or as a tripartite consensus. Okay. In deliberations between the parties, the Ministry of the Human Resource chairs the discussion and appoints government representative. Okay, next is workers are represented by the Malaysian Trade Union Congress. It means MTUC, and the Congress of Unions of Employees in the Public and Civil Service. It means CUEPESCS. Okay. While employers are represented by the Malaysian Employers Federation. It means MEF. Okay. So, the National Labour Advisory Council, NLAC, that meet at least twice a year or whenever it is deemed necessary. In 1957, Malaysia joined the International Labour Organization (ILO), an agency of the United Nations which play a role in the Malaysian industrial relation systems.
Hi, Assalamualaikum. My name is Qatrina Binti Kasani. I'm from DLS4B. Name is 23 DLS19F2054. Today I want to present about role of the Ministry of Human Resources in industrial relations. Okay. First, responsible for preparing the legislation which establish the right of employers and employees. The ministry required to enforce their implementations involve not only in industrial relations matter, but also in the enforcement of labor standard, encourage of safe practice at work, and provision of training for the workforce, ensuring the maintenance of a harmonious relationship between workers and their employees and their employers. Department of Trade Unions Affairs, it is actively help employers and employees who request assistance and generally take steps to improve the relationship between employers and their employees. Okay. We move to the next slide. Collective bargaining. Collective bargaining is the process whereby employers and employees negotiate the terms and conditions of employment. Have three organizations is give the union certain right to represent his workers. Okay. And organizations is if a group of workers have any dispute or disagreement with employers, they can use the machinery of the unions to take steps to bring about satisfactory settlement. Okay. Furthermore, the Industrial Relation Act Section 30 requires a union get the organization from employers before it can begin the process of collective bargaining. Okay, collective bargaining. Okay, the best method of regulating the terms and condition employments. Okay. The process of bargaining with the employers to improve the terms and condition of service of worker in the company. Once an agreement is reached between the two parties, there will be no discrimination between unions members and non-members in the term given. Okay, collective agreement. Collective agreement, written agreement between an employers and trade unions relation to terms and condition of employment. Okay, it is in order for collective agreement to be a valid binding contract, the law requires the certain requirement to be met. The agreement must be in writing and signed by parties to it. Further, the agreement must be specific their durations, which shall not be less than 3 years. Okay, that's all for me. Thank you.
So the last point is a summary. Employees have the right to belong to the trade union with some restrictions. All trade unions have to be registered with the Department of Trade Unions, failing which they and their members who have no rights. Once recognition has been granted, the process of collective bargaining may begin. Collective bargaining is method favored by the authorities by which employers and employees may come to an agreement on the terms and conditions of the employment of the employees concerned. That's all from my group. Thank you.